Mhm. Hello, hello, everybody. It is Arty of Arty's Corporate Fiction. How are you guys? Welcome. Yes, you know what? I decided. Well, I felt like I was peer pressured, by my friend, who's all here saying like, "Oh, you don't have to start at October 1st. You could just go straight to the spooky season right here and now." And I'm like, "Fine, fine. I'll do it. I'll at least change the theme." But October spooky streams are upon us. Starting on October 1st on my gaming channel, you will see me play Layers of Fear, the remakes, as well as Alan Wake 2 DLC and the Silent Hill 2 remake. Those are on the docket, so those should be a lot of fun. But today, we are going to pay attention to this video featuring Judge. Oh, God, I already forgot his name. What was the name of this judge? Ah, the name is. I'm lost. Anyway, because I know I've seen him before. I know, and I've seen him take down another sovereign citizen too before. Either way, apparently this guy has dealt with Sovcits before. I do know that. Oh, there he is, Judge Oakley. There we go. Now I see it from the name tag. Judge Oakley has dealt with Sovcits before, and apparently, well, I think that the title is gives it away that this guy's going to end up being held in contempt. So I'm very interested to see what's going on and how far we get. But appreciate you guys coming in. As always and forever, www.artysmerch.com. Get yourself a hat, get yourself a t-shirt before they sell out. The t-shirts are almost out of stock, guys. So you may want get your t-shirt as much as you can. Get your t-shirt while you can. So absolutely. Merchandising, exactly. And there's nothing new to update. Nothing else. Winston's doing well, as always, taking his meds like a champ. And Maik is kind of becoming a fat kitty. I think he's having a little bit of an extra share of the food, so I've been like gradually lowering the servings of dry food, at least for the boys, because I think Maik is getting a little chubby, hefty. There you go. That's a better way of saying it. Rotund, robust. How about that? All right. Anyway, let's get the show on the road. Yes, Lane, I do know that the next round of shirts will be black. Yeah, they'll be a black. Well, yeah. I bet they do, Iceblade. All right, let's see what's going on. I think I don't know if I'm prepared, but here we go.
So you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Oh boy.
Emergency motion stay needs to address the requesting the conditional bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crusoe?
It's covering all the conditional bias.
Okay, listen to my question.
Okay, I can barely hear what he's saying, so I'm gonna hope the subtitles will help us out here.
Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have a mistake straight to me telling you didn't give a shit about what I had to say.
Okay, hold on.
Oh,
this is
Okay, I did hear that one. Like, it's like something like you don't give a shit of what I have to say. Swearing in front of the judge in open court is not going to win you favors. That's for sure.
It's going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers as cheating agreeing telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this.
God damn it! Oh my God!
The Mog Miner just donated 150. They said spend at least some of this on the mini Cogit. Catch up with me soon. Smile.
Thank you, Mog, for the $150 tip. Wow. Thank you so much for that, man. Very generous of you, and I hope you got your money's worth, because I thank God that I didn't have my drink on me, because that would have been really messy. Oh, my goodness. Oh, I'm about to sneeze because of that. Thank you! Oh, thank you. All right. Thank you very much, man, for that. Oh, all right. That got the blood flowing.
All this should have been stopped a while ago.
That's not the way it works. Mr. Cooper, hold on. Hold on. Okay. That's the last time you're going to interrupt me today without a contempt of court charge. Is that clear? Is that clear?
Against me this entire time. No one has made her answer that.
One more word,
No.
and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail.
Ooh.
Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion.
Yeah. That's always something that the Sovcits love to ignore. It's like, wait. The judge agreed with the prosecutor. Obviously, it's because they're in cahoots, and they're plotting your demise and trampling on your freedoms. It couldn't possibly be that they know the law better than you do.
It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, that means that you guys are lying against us.
So that means.
Oh my God. So I think you heard him say that if you're agreeing with each other, then you're lying against me. Or I think you meant to say like you're plotting against me. Akira, thank you for the $4.99 super chat. Appreciate it. As always, will do.
In any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Cusel? No, you have to answer my question. Contempt number one. $100. Answer my question.
Cha-ching.
Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes
Cha-ching.
or no? Because I can do this all damn day.
Do I not have the sound effect? Oh, it would have been perfect, but I don't have one lined up. I don't have a cash register sound effect like at the ready.
And when I get tired of this game, then I tell them to put you in custody because it's contempt of court, criminal contempt in my view.
Yes.
It is. All right. So now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that?
It was.
I thought we were talking about Judge Green's SOS statement.
When you made the statement that you were setting aside my regular Travis, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting it out, like not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside.
My boy. Oh no. He's gonna sound like a disappointed parent. Thank you, Robert Cass, for the $5. Finally got a live stream. Congrats on the merch store. Great case. Well, it's already pretty spicy so far. We're only 3.5. We're only like less 4 minutes in.
Mr. Cassell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself.
True.
If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt anytime I tried.
I am threatening you with contempt.
Yeah.
No, because third contempt. Do not interrupt me.
There you go.
When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection.
What's your objection? It's devastating to my case.
That's why I said your objections mean shit to me because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately, properly, and to be perfectly honest, in your best interest.
And Your Honor, again, you're trying to spin this here.
I'm not spinning.
My objection is based on you not allowing me to do it. And that's what you told me when you asked me.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once permitted on the why it's on the prosecutor to prove those things. There's the false words and irregularities.
All right, let me.
Yeah, I can't hear. I can barely hear Deputy because the mic is away from his face. He needs to put the mic towards his face so we can hear this. Yeah, all I heard from that was like irregularities.
Stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You need to.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that? I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
I'd like to put on the record that whatever you would like to do from there, you can, because I'm open until these things. Like I said,
Hold on. Is this statement preceding all these motions you filed?
My husband had no idea.
Oh God, I forgot to switch to my other account. Sorry, hold on.
All right, so Mr. Crucell, you filed a number of motions.
Jury trial, and I think that waiting stating. That's the other issue of the trial, and not emergency stop, the motion to stop this.
I already ruled on that.
Use more of me.
Okay. Do you really want me to set that decision aside? Because that means those you or I have bias against you.
Hold on.
So I'm issued by the Township of Huron. So for that reason, once again, don't interrupt me because I can go to 4. Once again, you're not answering the question I asked. You just said you will not participate. And I asked, what do you mean by that? I'm not asking you to explain
the guy can't get a fair trial. Yeah, he's not answering the question. No, it was Otis. I think Otis is like a or Otter. Otter Insurance is like a car insurance company. You degenerate. Pleasure boy, thank you for the $4.99 super chat.
Your reasoning, I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You may not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
I'd like to put on the record that if whatever you would like to do from there, you can, because I'm open until these things. Like I said,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay, would you like to respond to that one? Because I think that's already been addressed.
Oh my God, kill me.
Please arrested Mr. Recusal while he was in Huron Township, but Beaufort District Court has jurisdiction over offenses that occur within the township, both civil and criminal. This is criminal and
Did you appeal Judge Green's decision on that motion?
I'm investigating because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct?
Getting all involved.
I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again.
Yeah, that's not how that works. Especially if you're at the same, especially if you're at the same level. I think barring some massively extreme circumstances, a judge at the same tier as another judge should not overrule the other judge's ruling. Like, absolutely not. Again, barring some psychotically high crazy circumstances.
And don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to.
The judge can't just come in here and say that there's.
Yes, the judge can.
Yeah, they can. Yes, the judge. That's the whole point of a judge making a ruling, is to determine whether or not the state has jurisdiction to move forward. That is literally what they're supposed to do, is make a ruling on it. The fact that you don't like it is your problem.
Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
So it's almost like I feel like the judge. I don't want to say he's new to sovereign citizens, because he's not. I know this for a fact. But he has to. Maybe he does this for everyone. But a core feature of sovereign citizen BS is they will not take. They refuse to take no as an answer. It doesn't, like, they will, no matter what a judge says, they will continue to argue no jurisdiction until they magically think that the judge is going to somehow relent, or either have a change of heart or relent and grant the motion just because they're being annoying. But obviously it never happens that way.
Also said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And I have all the recordings and they're submitted to the court. These things were never said to me. And then she comes here and makes these accusations and saying that the judge said this, the judge said that.
Fine. Then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the township of Huron issued you a citation. this court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next
All
one
right,
up
finally.
is motion to reconsider for bias and judicial misconduct. Denied.
Ooh.
Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
All the reasons that I'm saying there's.
Okay. Then guess what? The Court of
Mega
Appeals
bias.
can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk.
Ooh.
You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess.
Yep.
I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper after the judge over the trial.
Ah, so you admit you're the gatekeeper. Proof of corruption right there.
I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crusell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling.
Obviously not.
That's not a legal objection. So that's two motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
It's not what he wants.
Mr. Crusell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no? Yes or no? Do you want me to set aside those do you want me to set aside the default set-asides? Do you want me to reinstate those default judgments?
You don't want to do that.
Then I'll deny that motion.
Okay, good.
All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right.
Okay. Noted.
The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
Essentially, yeah.
Okay.
Yeah. Okay.
Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of
Robert Cass, thank you for the $2. I'm the gatekeeper. Are you the keymaster? Probably not. Maybe. Who knows?
non-consent. Oh, excuse me. Motion for judicial notice. What does that judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used.
Lawful terminology.
For example.
You use motor vehicle.
I knew it. I knew he was gonna say how the motor vehicle, driver, all the standard right to travel stuff. I knew exactly. Yeah, that was pretty. Well, I mean, it's pretty obvious.
Okay. Motor vehicles pretty much a term of art in our business.
law of differences between how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but
No,
I'm not the
you
trier of
can't.
fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument? Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go, everything's taking place.
No.
Exactly.
No, that's not the way it works, Mr. Cazell. No, Mr. Cazell. All right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Well, then that's why they have appellate courts for the 4th or 5th time. I decide what this jury gets to see today. I decide. That is, by definition, the role of the judge at a jury trial. I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. Mm-hmm. What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
That's my other issue with the trial, and I emergency stop, motion to stop this.
I already ruled on that.
Certain fact, acknowledge my motions for my next travel. Nothing to do.
Once again, I'm not trying to, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right. I am open-minded enough to think that perhaps my mindset about your whole travel thing, maybe that's all wrong.
Your whole BS.
So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
I said, well, you just keep, each judge has done the same thing. They just keep setting it aside and acting like it doesn't even exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my head.
What's your case that traveling doesn't mean operating?
I'm sad in the fact that this court's violated my due process rights in every way, the judicial bias and the
All right, then appeal me. But today we're having a jury trial.
an unlawful jury trial, and I think that late statement I need to get on the record.
All right, but hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is clear bias in this court against it.
Okay.
It violates my rights to a fair trial. 100%. And you want to keep overlooking. I know they make you seem like they're not a big deal, and
No, your rights are a really big deal.
Oh my God.
because if you can sit there and say that the things that are happening, the things you're saying, and just try to give these excuses, oh, just because I agree on this, you are aligning yourself with the prosecutor on my right to trial, completely setting aside, not allowing me.
Mr. Purcell, no, I'm not. Listen to me. No, it's not. Listen to me.
You did not say that.
She could step out of the room, and I still think your travel argument is bullshit.
Also true. Yeah, this is, it's not as if like the judge is like an empty shell and that he can only act on input from the prosecutor or defense. The judge has a mind of his own and an understanding of the law of his own.
Traveling. The right to travel was when you did it by Shanks Mare. Then appeal me. That's my decision.
Appeal me, bro.
When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have.
Oh, yeah.
Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized,
that, but also interstate commerce, interstate travel, as in going from one state to another. That's also important to know. But
then the rules kicked in.
Rulings from the American Jurisprudence sites that literally state that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this has been something that's been established to be secure.
Then appeal me. Take that precedent and appeal me.
As well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining it based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process
which is not an appeal.
Is an extreme, lawyer when there is bullshit that you can't do that.
Absolutely, I do that.
100%.
No. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure. Yes, you have.
I'm forced to be here.
But you didn't have to do it. You didn't have to do it as an untrained layperson. You had free access to qualified, competent legal
also true
counsel. They're still here. There's one right there behind you.
You put yourself in this position.
He's still ready to help you. You chose to do this yourself. That means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of evidence. And if I help you through those lapses in your knowledge base, that's not fair to the prosecutor. Then
Also
I'm
true.
taking sides.
Yep.
And now I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There is no partial anything. I have the.
Once again, Mr. Crusell, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And
Also, another thing that they don't understand either. And again, we see this all the time where, and I remember this being taught by my criminal law professor. No. Well, he was my criminal law professor, but he was also my evidence professor. And he also was, and I think this was the evidence class, where he was basically castigating all of us by the student's idea that all you had to do was just take a copy of a court decision and just wave it at the judge, saying, "Hey, this opinion says it does what I mean it to." If you're incapable of making the argumentation yourself and expressing it coherently in your own words, what the court what an opinion says and means, then you're not doing it right. But thank you very much, Sathea, for the 5 gifted memberships.
look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
Also true.
When Officer Price literally pulled up to me my letter case before any of this even happened and talked to us about the travel. He even told me I was well within my rights. Gave me every clarification that I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me. He even called me trying to say, "Oh, hey, motor vehicle." I was like, "What's that motor vehicle?" And then he goes towards the motor vehicle. And then he tries to get me to not pursue legal matters. And then he gets mad at me. And then the day that I file for my body cam, I'm getting removed from here on a little league.
And stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here, and I told you that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, every time I felt to make my case, basically the court keeps setting all my stuff and not allowing me to be heard.
Because I'm going to make decisions based on the facts. That jury hopefully is going to make decisions based on the facts that are presented.
How can there be facts if this court continues to not allow me to get my facts?
Because the facts you want to get into, what facts do you want to get into? The chief had some conversation with you?
It's not even just that. I mean, well, yeah, regardless, I have all of that to cover too. The fact that my defense, based off what I was doing, I didn't have to produce any of that. It just keeps all just thrown aside. Every single and just not even trying to acknowledge any of it.
So hold on. I don't understand. Hold on. You want to be able to testify to this jury?
No, it's not. I'm not testifying. That's what I'm saying. It's the amount of traditional bias in this case.
I'm done hearing about bias. You need to appeal me. I
Don't care.
I don't feel I have bias.
Well, I don't feel that I would have a fair trial here with everything that's been taking place. Why I filed policy? Why I didn't.
And I've denied all these things.
Well, of course you can deny it again. Showing them again that this.
Once again, Mr. Cruzel, just because I disagree with you doesn't mean I'm biased against you. Maybe I just think you're wrong. Is it possible we could have a difference of opinion?
Tina Green told me that she was just not announcing herself because the Secretary of State will make sure that this isn't a big deal. I'm showing them.
I'm not going to.
It's no impartial sport here.
I've never brought a Secretary of State, have I?
This is where this all stems from. These are the things I've been trying to get noticed. This thing talked about.
What do you want getting noticed that we're not getting noticed?
The fact that this collusion and judicial bias.
It is not collusion.
Collusion.
What? All right, listen. What are you going to do today? Because I'm ready to bring the jury in. I've denied all. Stop. I've denied all your motions. I'm ready to set the trial. Are you not going to be here?
Your Honor, has established nothing is even put in here, right? And especially regarding the jurisdiction stuff.
Once again, we're at $300 now. We're going to $400. I'm going to ask you the question again.
Uh-oh.
I'm ready to call the jury. Are you going to leave?
There's no way there can be a fair trial here.
That didn't answer my question. I need to know how I'm going to proceed because we can have the trial if you just sit there. I'll just tell the jury you've decided to represent yourself and you might not say anything today. So that's the way you want to go with the trial.
I do. So these against that.
Okay.
Everything is on.
Okay. Okay. No, let's on the record as you feel they should be.
I brought the sites that I left the sites at home and bringing up the person's jurisdiction.
And hold on. Once again, I want to just because he just walked in the room. Once again, I want to let you know there's a very competent, experienced legal attorney here, defense attorney here, that's more than willing to help you with this if you want his help.
Well, the sport actually was supposed to be.
And that ain't gonna happen.
Anybody showing you were supposed to reduce yourself. It's in the book.
And I don't think I've shown bias. That's what we keep. Once again, you and I disagree.
Yeah, so at the first, usually in most states, not all, but in most states, the judge is allowed to, the judge for which is being accused of bias is like the first entry of determining whether or not they're acting biased towards the party that's filed the motion. I know it's like, what do you think they're going to say? Of course, I'm not being biased, but usually usually most states, the judge who is being accused of being biased will make that determination on their own, and if the party disagrees, they can move it up top.
Disagree. That's okay. That's America. You have to appeal me. You don't just keep to argue. You don't get to argue the same thing over and over and over until I agree with you. That's not going to happen. I know I am not biased towards you. I also know that your ideas of how the law applies in mine are vastly different. But because I'm in the black robe and I'm in charge of this trial today, my ruling stands until a circuit court judge or some higher court tells me I'm wrong. That's just the reality of it.
That's what I want to do. Because clearly this court's not going to rule it the way it's supposed to. Not going to stand by your
Not by your definition, I'm not.
Secretary of State, Attorney General, and you. I've never heard anything. I don't even know if you're lawfully allowed to concede it. You can say that again. It's been proven on the record.
No, it doesn't need to be proven on the record. Show me a statute or a court rule in Michigan that says I got to prove that. Statute, Michigan statute, or Michigan court rule says I've got to do that.
I have it in there.
So You're such a great legal scholar.
MCL 168.420 and MCL 168.467 mandates that it doesn't must file with the state, and you provided 1X. That is what you have to ensure.
Okay, then I don't have it. You can file that motion to dismiss with the circuit court. But we're having a trial
Thank you,
today.
Liz.
We're gonna have Bob going to participate in a trial that's going to be impartial against them, right? It's going to be completely. There is no impartiality that is supposed to be here. There cannot be a fair trial for all of the amounts of evidence in the hand.
Okay, anything else you want to put on the record before I call the jury in?
Yeah, lengthy statement I would love to put on the record before we get.
How lengthy?
Minutes.
Go ahead.
Oh, boy.
Respectfully, sir.
Just so you know, you're putting this on the record. You're putting this on the record. I'm not listening. Showcase the record.
Your Honor, Judge Oak, I respectfully assert this court has failed to motions by files of the case. Yeah, well, then so she can make.
Thank you.
I respectfully assert this court has failed to address.
I am not
the
saying that out
motions I
loud.
filed in this case, including a motion to dismiss for lack of jurisdiction, a motion to recuse for bias, and a motion for relief from judgment. These motions have raised significant concerns about the court's jurisdiction, judicial bias, and violations of due process.
Cindy,
under both
thank
the Michigan
you for
Constitution and the U.S. Constitution, particularly the 5th and
being a
14th
member.
Amendments. I have also submitted affidavits and motions, including an affidavit of truth and an affidavit of rebuttal regarding the traffic stop by Officer Merrill, which is connected to this case on August 21st, 2023. Citation number 24HR 101-430, which this court also ignored. These documents directly challenge the jurisdiction of the state in this court, and failure to address them constitute a violation of due process rights. Additionally, I have filed an affidavit of not consent, a motion for judicial notice, a motion for clarification of accuser, none of which were acknowledged by the court. In Marbury versus Madison 5 U.S. 137, the U.S. Supreme Court clearly established that any law repugnant to the Constitution is void.
All right. If you're citing Marbury versus Madison in a traffic case, you are way too far gone right now.
I believe the actions were lack thereof that was forced by the fundamental constitutional principles. In Murdoch versus Pennsylvania, 319 U.S. 105, the court reaffirmed that no state may impose fees or penalties for exercising a constitutional right. And Thompson v. Smith 155 reinforced that the fundamental right to travel freely without undue interference. Additionally, Title V USC 556D, 557, and 706 require that any judicial or administrative proceeding be fair, free from bias, and based on factual evidence. I have serious concerns that this court has disregarded this evidence. I have serious concerns this court has disregarded these principles, given its method of dismissing my motion.
What evidence? This isn't evidence. These are legal arguments. Legal arguments are not evidence.
Some statements made by Your Honor, who has stated on record that we see things the same way, referring to the prosecutor, township, state, and this court. This admission clearly demonstrates judicial bias and lack of impartiality, which undermines the fairness of these proceedings. It is also significant that Judge Tina Green has admitted in court that the Secretary of State is influencing the rulings, stating that the court is required to enforce certain rulings because of the Secretary of State makes them do so. This further demonstrates that this court is not acting as an impartial judicial body, but is enforcing motor vehicle codes and other rulings based on external directives rather than applying the law independently. The Secretary of State is an executive branch agency, and his influence over judicial proceedings is a violation of the separation of powers and the constitutional right to an independent, fair trial. Furthermore, there is clear evidence of collusion between the sport prosecutor, Huron Township, including the Huron Township Police Department. I have submitted body cam footage highlighting violations of department policies by several officers, including Officer Merrill, Officer Sinai, Officer Smith, and Chief Everett Robbins. These violations occurred even after Sergeant Price confirmed that my activities were lawful. Yet this court continues to overlook these crucial facts. Officer Merrill's traffic stops of both myself and my wife are connected to the ongoing retaliation against me and my family, which has compounded the bias and misconduct in this case. Additionally, I have requested Your Honor's oath of office through an affidavit of fact, registration statement, demand request pursuant to the Foreign Agent Registration
Oath
Act
of office.
1938, and anti-bribery statement request, and I have received no response. This lack of response raises further questions about the legitimacy and legal standing of this court. Moreover, Judge Lisa Norton issued an unsigned default order without jurisdiction or court seal, and during court proceedings, she admitted she did not understand the sui juris. These actions reflect further incompetence and violations of
Yeah, because sui juris is an archaic Latin legal term. It doesn't surprise me that some judges don't understand what the hell you're talking about when you say that.
due process. I must also address the township's deliberate attempt to mislabel my private automobile as an off-road vehicle under local ordinance to circumvent my constitutional right to travel. This mislabeling is an attempt to subject me to commercial regulations that do not apply to private, non-commercial travel. This ORV ordinance was never intended for law public roads. Under the Fairfield Trust Code, verse United States 318 U.S. 363, when government entities operate in a commercial capacity, they lose sovereign immunity and are subject to the same legal standards as private corporations. The court's actions, including the misapplication of commercial motor vehicle codes, further demonstrate its commercial interest in misinterpretation of the law. The supremacy clause.
Why are you, if you're arguing that you have the right to travel, a complete right to travel, why are you then trying to distinguish yourself between a private and commercial entity? I mean, wouldn't a commercial entity also want to argue that they have the right to travel too?
Clause of the U.S. Constitution, Article 6, Paragraph 2, mandates that this court is bound by the Constitution, which is the supreme law of the land. This court, however, continues to proceed without regard for constitutional protections, violating my rights at every stage of these proceedings. To continue under these circumstances would be a violation of my constitutional rights and an abuse of the judicial power. I respectfully
Andy, the judge went off for a smoke break. I don't know.
request the court issue rulings on the pending motions, including a jurisdictional challenge. They immediately dismissed this case by citing overwhelming evidence of judicial misconduct, bias, and due process violations. So these issues remain ignored. I will seek immediate appellate relief, hold all parties accountable, including Your Honor, Judge Martin, Judge Tina Green, Prosecutor Caitlin Margaret Foley, Officer Miro, Officer Sai, Officer Smith, Chief Everett Robbins, and the Huron Township Police Department. I further assert that if this court continues to proceed under the presumption that I am engaged in commerce, it must present evidence to substantiate its claim. Without such evidence, this court has no authority to enforce commercial motor vehicle codes or ORV ordinances upon me, and any further actions would be unconstitutional and unlawful.
No authority.
All
Okay.
right, here to court this report back in session.
Oh.
Bring the jurors in.
We're back.
Mr.
Anyway.
Purcell, just so you understand the process, we're going to do voir dire. Did you have a chance to talk about the iPad?
Excuse me, Vladaya.
No.
Hold on a minute, Joe.
Yeah, I told him I would go over it.
Okay. I understand that's your position, but I'm still going to explain things as they go. All right. I mean, I just want you to understand what's going on. So if you decide you want to jump in, you'll know where you're at. Understood? I'm not trying to talk you into participating. I'm just letting you know what's happening. I'm going to explain things as we go for you and them. You got that?
I suppose I don't understand why I need to sit here and use my time for an
Because if you leave, I'm going to ask you a bench warrant and you're still going to have to deal with us down the road.
True.
At least this way, listen, here, one of two things can happen today if we have the trial. Either they find you not guilty and you're done, then you can file all your grievances and stuff, or they find you guilty and you're just filing one more appeal.
instead of wasting everyone's time.
You've already wasted their time because they're all here.
You've
They're all
obviously
here.
wasted everybody's time.
Well, that's why I filed these things weeks ago. These things should have been addressed before this process even took place.
There's a scheduling issue that takes place too.
So
But hold on. Hold on. Don't interrupt. You didn't appeal the last round of decisions. You didn't appeal the decision you didn't like from Judge Martin. You didn't appeal the decision you didn't like from Judge Green, and you didn't appeal the decision you didn't like from me last time you were here. So here's my problem. I'm not going to adjourn today because you say you're going to appeal, because if you don't, we've accomplished nothing and we're no further to resolving these files.
Wasting more time.
Appeals court that I
Hey, welcome, Big and Raiders. Welcome, guys. Thank you for so much for the raid. Welcome. We're watching this one. I'm sure you guys have seen it already, but I haven't yet. But it's been this. I'm surprised this guy isn't in handcuffs already, but that's where we're at. But welcome, everybody. Thank you.
I've been in contact with the appeals court.
Okay. Hold on. Let me try to educate you. Okay.
Ooh.
You contacting the appellate court. First of all, this should go to the circuit court. All right. You've gone. Okay. So I didn't choose for you to be here, but you're here. Okay. So we have to get through it. All right. So the way it works is you don't just talk to them about an appeal. You actually file and perfect an appeal, but you didn't perfect the appeal.
Yep.
So there is no appeal. You started the process, but there is no appeal. So, Mike, we're going to go forward today. The only question is, are you going to be in the chair now?
No, again, if you were prevent for, I'll have to stay the bottom one, correct?
Depending on what I set the bench warrant at,
Mm.
can be whatever I want it to be.
Yep.
Once again, but see, you think that's bias, right? And that's me explaining to you the way the process works. I could set a $10,000 cash.
It's like explaining the consequences of the potential consequences of your actions is not showing bias. It's just stating matters of fact, man. Kez, thank you for being a 23-month member. Laura, thank you for the 7 months. And Holden, thank you for the 14 months.
Bail on this. And until a circuit court judge tells me that's got to be set aside, it's the bail. That's the bond I set if I set it. Because here's the thing. And I'm trying to, listen, dude, I'm trying to get you to see I've got a job to do. It's got nothing to do with you personally. All right, you keep bringing this, I'm having so much trouble getting through to you. I'm thinking the next step is a competency exam.
Oh, nice. Oh, wrong button. Fletcher boy, thank you for the $4.99. You say braces, but these are suspenders. Are they called braces like in other regions? I don't know. I've always called these suspenders. Lane, thank you for the gift of membership. And Sparkle, thank you for the 2 months.
So that fact that she told me that on the record in front of her, and in all the things that she's saying, the judge said, she never said that on the record. I have the record submitted.
So once again,
told me she wasn't doing this because of the Secretary of State.
Then appeal Judge Green's decision. I've told you that at least 5 times today.
Of course they'd be called braces in Bongerland.
If a district court judge makes a decision you don't like, you appeal it to the circuit court. You don't just keep arguing again. That doesn't get you any further along. So if you don't participate today, if you just sit there, that's fine. We'll have a trial. You can jump in if you want to. You don't have to. I mean, in any criminal trial, the defendant doesn't have to do anything. But at each step of the game, I'm going to let you know what your options are. So for example, when we do voir dire, I'm going to ask questions of the prospective jurors. She's going to ask questions of the prospective jurors. You can ask if you want to. You don't have to. All right. When it's time to pick the jury, she has a certain number of challenges she can use. So do you. You don't have to exercise those challenges, but that's the way we pick the jury. Do you understand that process?
I've been trying to get all this stuff established with the courts and the and I still have evidence that I'm trying to get from the township that they're using lead codes to redact, which they did with the policy information that I tabled and got them to give me the policy because they were trying to do things on.
Okay, stop right there. Hold on. Stop right there. Stop right there. That's something new evidence you're waiting for. What are you waiting for?
This is where I haven't got it to even get to.
No. Tell me what it is. What
Evidence that like that I requested from lawyers in the very beginning with my bottle camera.
No. But what is it? You're looking for some records, some ordinances?
Part of the traffic stuff, comments and things that were put in there that.
Hold on. In where?
In the comments.
You don't have police reports?
Well, I do, but I found out that they withheld certain documents that when I filed my FOIA, they didn't give to me. And then upon doing more filing for more stuff, I uncovered that they withheld certain documents. That are getting the whole thing.
Hold on, let me hear what you just say. Just hold on. Go ahead. Do you have any?
I was going to say, you shouldn't be using the public records access to get potential evidence for your case. You should be getting that through discovery. Especially if it's like, if you're trying to find the body cam footage or the police report, that's supposed to be provided to you in discovery.
Any idea what he's talking about?
He's bringing things from the south and
You mean like the officer's personal notes?
Had notes.
And, for example, body on camera where they're sitting in their patrol car and the computer's on. Those are all mean material that can't be discoverable. It can't be shared with people outside.
Wait, what? What? Michigan, what? That's not discoverable? Hold on.
All mean material that's sitting in your patrol car and the computer's on. Those are all mean material that.
Lean material? I have... What the hell does that mean? Hold on. I gotta find this out. What the hell is lean? Lean material. Hang on. Okay. Google's not helping me. Shut up, Google. What? Didn't ask you. Lean, like, it wouldn't be like lean as in Lein. That's something completely different. It would be like, you know what? Let's test this. Is body-worn camera footage discoverable in Michigan? I mean, it does say here that it is discoverable. According to this policy directive. Oh, but this is for the corrections department. Let me see here. Footage. So, I mean, according to this legal website, it does say that you can get it. So I don't understand what she's saying
Can't
here.
be discoverable. It can't be shared with people outside those that are, have the security clearance to observe or handle the material. So that's what he's referring to.
Okay.
That's not what I'm referring to. The notes on the computers and stuff, that's not what there's even stuff that was in the body cam that when they were talking to the chief that they purposely redacted out of the conversation to the notes.
Oh, okay. I'm sorry. I completely missed it. No, he's not. Okay. He did get the body camera footage. He's just pissed off that they redacted certain parts of the body camera. That's what she's saying. Okay. That's what it is.
Are completely all redacted. It's nothing to do with computers. It has nothing to do with personal information and names or addresses. There were things that were stated in conversations that were taking place in these notes.
Let me stop you. During the traffic stop?
They withheld this when they should have given it to me in the very beginning with my FOIA for everything that's involved in my traffic stop. They didn't.
Okay, hold on. I'm trying to clarify. Are you talking about like, I don't want to say this. Personal comments between two or more individuals
No,
That-
not versus boundaries, it's stuff that's logged through the traffic stop. Like,
No, stop. But I gotta understand what you mean. Logged through the traffic stop. You mean it showed up on camera and then they edited the camera?
Yeah.
Or edited the recording?
As well, and there was no clear reasons why, every time I'm trying to get reasons to why they did it, what it's next, because they're supposed to label why it is. I haven't got anything, and then it's in the comments sections of like what was going on.
Hold on. Comments on the incident report?
It was just, it's not the incident report, it was through the, while the traffic stop was taking place, stuff that was being entered through, like. I can't remember exactly what the paperwork is right now, like I said, I'm in the process of getting that all. I'm appealed it to the supervisor, and then he vaguely gave, just cited statutes and codes, but he was supposed to tell me how and why any
Statutes and codes, drink.
is even applying to the lead sections, which are failing to do because same thing with.
All right, so hold on. So what I'm hearing, I want you to confirm whether or not I'm hearing it correctly. I think what you just said was those comments section things that you want, they're telling you that's all lien stuff and it's protected.
Yeah, it's like when I have other.
Hold on. Is that a yes? That's what they're telling you?
Essentially.
Okay.
So, and part of the design of the whole thing, paper I got from them, they didn't do it in any of the other ones. Only.
Hold on. Other one what?
Other than all of the, because there have been several reports, several times the cops came out of their house, but we were told, well, and also, this has been going on for all of the years, probably by incident happened.
Okay.
So I filed get all of every cop that had been there, all the reports, anything to do with anything that I could get that was access to me. And then that's how I found out that these other reports weren't released to me. And then in my life traffic stop, they did the same thing. Everything to do with that entire traffic stop is all completely redacted. But yeah, the other stuff, it's all open.
Redacted from,
The whole page is just black.
hold on, redacted from the incident report?
Yeah, from the incident.
The paper report that you received?
Yeah, exactly.
Okay.
And there with no justification involved. Why any of these things are redacted, I keep trying to, and how they did it with the policy. I tried to get the policy 3 separate times to the department, and then they cite these lien codes for names and addresses and stuff, which I understand there's certain stuff.
What policy?
The policy conduct for officer conduct and how the officer is supposed to operate themselves, right? So they died several times.
Okay, I think I now understand. I think lien is like Michigan's like privacy statute or something like that. So that's what we said, like they just cite like these lien codes, meaning he's citing to a particular section of the statute as to why this information is redacted.
Stating the same lead codes are trying to fix all these redactions now. So I appealed it to the township supervisor, and he released all of my information. And it showed that the policy showed that these officers violated the policy and
Okay, hold on. Stop. So he released everything, but not everything you want?
well, then once I realized they were doing this, I went back to getting more. That's how I found out there was more stuff that was never released to me.
Okay.
And then doing the same process using these lead codes to not let me see what was put in this paper. And that's why I told the American Titans. I've been trying and fighting all this full time trying to get this stuff together. And I'm getting every which way I'm being screwed.
He's raising issues that concern me. Because now we're talking about discovery requests that are being partially fulfilled.
As you can see, as it is with this stop, he does have the incident report. He does have body on camera for 4 officers in car, dash cam, what have you. He also personally took a video. I don't have it. There was no mutual discovery. He elected to use the FOIA route to take all this information. What he's referring to again is the CAD information where there is no material. None of that affects what the substance of the incident report or the body worn camera or anything of that effect. He's also talking about incidents that I think they were probably about the township attorney is dealing with it as opposed to the township prosecutor. There's probably about 20 different contacts that he has sought FOIAs through. So it's not just this incident. And what I suspect he's talking about where police may have came to his house or like a traffic stop or speeding ticket, there are no incident reports. Those are CAD notes. So that's probably why those are blacked out as opposed to this incident where a misdemeanor was attached and an incident report had you with that.
Okay, so if you heard that, normal what she said was normally in a civil traffic issue, an incident report wouldn't be made. They would simply be there's simply only be like a CAD, a dispatch log. CAD is computer assisted dispatch. It also sounds like she said that maybe the reason why certain documents that he has are heavily redacted is because he tried to get access to these documents using the state's public records access law, which inherently would be um, subject to more restrictions on access than if he was to get it in discovery.
Okay. Anything else as far as information you requested that you don't have that you think you need?
I mean, that's the base of it. I'm still actually, now that I've been having to really dig into stuff, I'm uncovering more now that I've been through the body games. I have to file more to get more stuff unredacted because there is clear points in these conversations that were purposely redacted. They have nothing to do with clean information that they keep claiming. Same thing with these cat notes she keeps referring to. That's not what I'm trying to get hold of. And I understand that there are things that they can redact through the lead code. These entire things that are, there's no way the entire pages and these comments and everything are all lean information. And I know that I've even told.
How do you know?
I've been told for Sergeant Price, things that are said in these personally about me and stuff like that are being redacted because it can be used showing the bias and everything retaliation against me. And I know for a fact what was said of these things. That's why I know it being redacted is more than what you say.
Okay. But Mr. Crisell, with all due respect, that all sounds like a civil lawsuit against the township.
True.
Well, yeah,
Thank you, Deadpool, for the 199. I got a shout out from Moist. Oh well, I appreciate that, man. Thanks.
this is my arguments I've been trying to bring into this court, but everything's just being keep getting.
Because I'm not going to get into all that with a jury.
But that goes directly to this, is what I'm saying, and that's why I've been trying to get all of this stuff answered before we even come to this point.
I'm not going to let you get into all that with a jury. It's going to be confusing. We're going to go down rabbit holes.
That's why
What's-
I'm prepared, because I need to be able to present my case to
Sure.
fair.
So this case goes back to February. We set this trial 2 months ago.
You're right, but
2 months and 2 weeks.
trying to get the jurisdiction established, I'm trying to get the judicial bias stuff taken care of, all of these things that have not, that they've just been it is what it is, just getting swept under the rug. When
Okay, hold on. Once again, I have to take offense to that. I'm not sweeping your judicial bias argument under the rug. I'm denying it.
without it, I give it, yes.
Okay? No, seriously. See, it doesn't matter what you have to say. If I'm determining bias, I know what my heart is. Now, you appeal that decision or you grieve me to the Judicial Grievance Commission, right? They can look at all your facts and say, well, Oakley, clear bias. But I don't have to hear all your arguments and see all your evidence to know I'm not biased.
That's fine, and I guess that's something that I have already started to do about this, and I will be going down it, the more I look at it.
Okay.
So again, I,
Sir, it's 9:02. The jury's been here since, I'm assuming shortly after 8, some of them were showing up.
again, like I said, I cannot participate in something that I know is not, it is stacked against 100%.
Well, once again, you think it's stacked against you just because you don't agree with the way things are going. Okay.
It shows that these things have to be established, that there has to be.
Then
You see, bias, but that, see, I mean.
okay, stop. We're just hashing the same arguments again. If you're right, then you've got an automatic appeal if they convict you today. If you're right, and this whole thing has been nothing but a sham,
It has to be, and it's all this turned into.
okay, bring the jury in. I'm tired of talking.
Uh-oh.
That's the motion will be real quick.
Motion who? Oh, I forgot you file a motion. Give me just a moment. Yeah. Yeah. Did you see that? Hold on. Did you get her motion?
I've never seen anything.
Yeah, no. You got a copy, you can just at least show him so he can see if he's seen it before.
When did you send this to me?
Last Tuesday along with our consultants.
I have never seen this.
Take a minute to look at it.
I would also like to bring up for the record too that
Hold on. Hold on. Have you had a chance to look at what you just handed me? Okay, all right. So are you ready to argue that motion?
Well, no, I had no time to prepare for anything next time. I've never seen that before, and
Okay.
it's just trying to keep me from being able to bring up all my valid arguments that are all applied to this.
Once again, valid as you determine them,
It's advanced to the case.
as you say.
And that's, and they're saying me the things they're trying to say, right? They have no evidence. Where's the evidence, right?
Right, but I haven't ruled that anything she's trying to put in front of the jury is invalid.
So my defense to my.
Well, here, let's do it one at a time. She wants to stop you from saying anything about due process violations. Did you plan on telling the jury that your due process rights have been violated?
All part of this case.
Okay.
Same thing with all the way to the traffic stop, all the way till now.
Specifically, what were you going to tell them about your due process violations?
Well, I don't have my defense completely in front of me because I'm, again, trying to get all the other matters. I'm not ready for that, so I've never even seen it, so I can't even build up a defense to that to produce.
How was that provided to Mr. Crusoe last week? Okay.
I received his motion, or his motions on Thursday, so it didn't give me much time to respond. I did send it in the mail, I dropped it off at the post office. And I didn't receive his most recent motion.
That was filed Friday. Right.
I said it
Yeah, I
last
think
week,
the
I
17
know issues, we've never had first last name. Never.
All right, so here's what we're gonna do. If you decide to participate and present any evidence to the jury today, then if any of these A through E's come up, we'll deal with those as a point, on a point by point basis. Understood? I'm not, sir, I'm telling you, you don't have to. She wants me to give you a blanket instruction right now that you can't talk about any of these things that are listed in this motion. I'm not going to do that.
Especially think of the
If you choose to present
8
anything
months.
to the jury and one of these topics come up, she's going to stop me probably with an objection, say, Judge, could we talk about that? And then we'll talk about that. Item by item. Understood? All right. Anything else before we bring the jury in? You said you wanted to say something before the jury came in. I thought you said.
Another key point to this, I filed for records requests to this court, trying to get all my court hearings and everything in recordings. There's still one from the very first one from Judge Martin that is crucial to this case. They still have issues.
How could it be crucial to the case today?
Second rule in there, absolutely huge to all my whole.
No, they're not. No, they're not.
All of this.
No, sir, everything started on February 3rd, 2024, when your tickets were issued. So anything,
Then I take it as default.
let me answer. I'm trying to be patient, Mr. Crusoe. Anything Judge Martin said at a hearing about those tickets after February 24th, or February 3rd, 2024 would not affect the facts of what happened on February 3rd. Agreed?
Mhm.
But it affects what is going on with this court, as far as the fact that.
The only thing that's going on with this jury is deciding what facts took place on February 3rd and how they apply to the ordinances the township is trying to apply.
Yeah, they're getting going out of that, but again, like I said, I'm not gonna subject myself to sitting here through something that I know.
Then get up and leave, Mr. Crusoe. You're not under arrest.
True.
I've already explained your options. I've tried.
True. If you don't think this court has jurisdiction over you, why are you here? Get up and walk away. And then you'll find out whether or not they have jurisdiction over you.
Try to be as clear as I can with your options.
Like I said, I will not participate in this. It's clear, there's all sorts of stuff going on here that's great against me.
I understand you feel that way, but I've got a trial scheduled today. Something's going to happen. Once again, if you get lucky, they find you not guilty and you're done with this stuff.
Can I take a minute to figure out what I want to do with this?
Absolutely.
Yeah,
Oh,
thank you for
one
the
thing I want to
$2.
make clear. The civil infractions don't go to the jury. You understand that? That's a formal hearing. That's just between us. You understand that? We'll deal with that after the trial if we have a trial today. The misdemeanors will be in front of the jury. You understand that? Okay, take a minute. Make it quick though. I hate to have the jury wait. Mr. Crusoe,
Yes.
Mr. Bowditch is available. Doesn't cost you a thing just to get his opinion. All right,
Just saying.
go ahead.
Free lawyer right there.
We go with female.
I suggest.
Yeah, you ready for Phoebish, the plea? Bring him in. You just push record and go.
If you didn't hear it, he said he asked if he could have a few minutes to decide what he wants to do, i.e., whether he wants to go through with this trial or like just leave, I guess, and then get a bench warrant against him.
He's going to sue.
I hope. He's like Phillips. I tried to tell Phillips, like, look, dude, waive your jury and I'll let you talk about anything you want to talk about.
But he didn't waive a jury trial, of course.
But he just got this thing that I don't like him. He's grasping eventually. He's not thinking right. What I'm gonna try to do is convince him to do a bench trial, and I'll get the whole freaking day. He can make all the arguments.
Oh, that's true, yes, so, that means we can do the other one on that one.
So it'll be a special day.
Okay.
Security. Hey, tell them they don't have to have a final decision. I just want to know if I can send the jury home. Okay. I got no problem giving you more time to talk, but if I'm letting the jury go, I just want to bring them in so I can talk to them and let them go. You can keep talking. You sure? All right. Bring the jury in.
So I go back here.
Yeah, keep talking. Keep talking. Hey, Jeff, come here. Mr. Crucell, I'm going to give him an idea to talk about with you.
Okay.
Uh-oh.
If you listen to the Sean, I'll give him a whole fucking for bench trial. He can bring every argument he's got. Oh, but I told him.
That's what I told him.
But I'm just not doing it with
I said, I wanted him to ask you politely to reserve his right to a bench trial.
Yeah.
And all of his information, he's going to get together.
Just let him know that that's what I wanted you to know.
And
Go tell him.
I'm not going to represent, but I'm going to help him.
All right. Go tell.
Honestly, sir, your professionalism is wasted on this ass clown, sir. But I have the utmost respect for you of doing your duty, even though honestly, you don't even have to go this far. If he's like refusing your help, you don't have to help him, but you're helping him anyway.
Tell him that I made that suggestion. So Caitlin, I gave him an option that if he'll pay the $300 court costs, jury costs, I'll give him an adjourned date so he can perfect all his appeals that he says he wants to file, and we'll send the jury home.
But do you think he's gonna pay?
Oh,
He already owes us. Oh, he only owes us the money on these.
yeah, I think he'll pay. Is it hot in here or is it me?
No, it's just you, but.
So it sounds like he made an offer that if he paid $300 plus the cost for the jury, then he would adjourn this and allow him to move forward with appeal.
Have a seat, folks. And Caitlin, you don't have to stay for this if you don't want to.
This is Judge Brian Oakley out of the state of Michigan.
If you suggestion, when you litigate, he's taking that suggestion.
Yeah. And Bowditch has already suggested what? You don't do a jury trial. This judge will let you talk about anything you want to talk about. Which is what I just called Jeff up to the bench and say, look, I'll give him a whole day. He can make his trailing arguments. All right, back on the record with the People versus Crucell. All right, Mr. Crucell, I just want to put on the record the conversation that we had out in the hallway with Mr. Bowditch present. Outside of your hearing, by the way. That's for that. But I filled you in. So you've agreed, you're going to pay your $300 contempt charge. I put that in air quotes. I'm going to apply that towards the cost to pay this jury panel for being here today. Agreed? In exchange, we're going to pick a date, hopefully in the next 2 minutes. We're going to pick a date, put this back on our calendar down the road to give you plenty of chance to perfect your appeals, whatever you want to appeal. Agreed? Okay. All right. You can sit down. Okay. Now, but I have to say some other things. All right. Before I took the bench, I did a lot of court appointed work. All right. So I know that a lot of times when a defense attorney's talking to their client, they've got to get over a mental hurdle because a lot of people in a situation where the court's provided the attorney, they think the attorney's not working for them. The attorney's working for the court. So I want to make sure you understand how this works. Mr. Bowditch, although we've worked together for years, he doesn't work for me. Really, he doesn't even work at my pleasure. I suppose if all 3 judges in this court told the Michigan Indigent Defense Council Regional that he works for that we just don't want this guy in our courtroom anymore because he's just incompetent or whatever, they'd probably put him somewhere else. But other than something drastic like that, he's not here because I'm paying him and I've requested him. You understand that? Okay. His job, his client is MIDC. And I say his client because they pay him. But he's paid to represent folks in district court that don't have their own attorney. I just want to make sure you understand when he's giving you advice, he's not telling you what he thinks is best for me. He's telling you what he thinks is best for you. Okay?
MIDC, Michigan Indigent Defense Council?
Now, the other thing, I'm assuming he brought my offer out to you. Listen, if you want to get into all those arguments that you've referenced today and the last time you were here, I'll give you that. I mean, I'll look at all the stuff you've got on the traveling argument, everything else, because what I told you earlier is I've got an open mind. Okay. I don't think in my heart of hearts, you can convince me that your argument on traveling is a valid one, but I'll listen to everything you've got to tell me on that and every other issue. I mean, I'll give you an entire day set aside for a trial to do all that, but not with a jury.
Mad Hatter, I think with those 22 months.
All right. So I want you to know that's an option. I'd like, and if you need to have some conversation with your family or Mr. Bowditch, I'd like a decision on that today, because when you walk out of here, I'd like to have a date on the calendar for either a bench trial or a jury trial. Okay? And I hope, based on my earlier conversations, you understand why I can be much more free and easy about what I let in when it's just me making the decisions than it is with a bunch of jurors. All right, Bowditch, go ahead.
We actually adjourn this, now, Priscilla and I have had a conversation. I think we can streamline this case quite a bit. Could we set another motion date? It's nothing that's been covered. We covered new ground.
Okay.
This would be a simple motion, with his understanding, it's yes, no. And then if we need to proceed to a bench trial, we would.
How far down the road?
Well, it depends on how long his discovery is going to take, if there's anything even possible to be retrieved. But I still do a month or so.
Probably a month is too tight.
Well, that's in the process. I've already appealed to the conference. I'm in the process.
Okay, hold on. I think so. October 21 is too tight.
Man, so somehow, this judge actually got through to this guy, and he's actually listening to a licensed attorney.
I think. October 21, I think, is too tight. Time frame wise, you want to go into the next month?
We can, Your Honor, it's up to the courts.
I have no idea how that process is going to work, so I don't know.
Yeah, I mean, I'm more time.
With what the court's done today and asking more favors.
No, you're not asking a favor. We're just scheduling a date.
Do you do?
What is it?
That's a Monday before Tuesday.
Yeah, that was
We'll
safe.
open that day.
That'd be safe.
If Caitlin is.
Do you have an opening on Monday the 25th? You're not scheduled.
Of November.
Just for a motion. This is just a motion hearing. We're not going to take testimony. Okay.
As long as you're not, no,
Don't-
you don't have them that month, let's say.
So that'll work?
What's the date?
9 a.m. the 25th of November? It's the Monday before Thanksgiving. Nobody's got travel plans?
Motion date.
Okay. So I think what I'm hearing is you think that will either be dispositive or we'll set a trial date that day.
Yes, Your Honor, or we'll resolve.
Okay, all right. Okay. I didn't ask. Can you pay the $300 today? Okay. And I implore you, keep talking to him. Keep talking to him. All right. Anything else?
Please.
All right. We're adjourned. Yeah, go ahead.
Officers are here and you guys are ready to testify if you want.
Understood. Understood.
Yeah, I got a card. Joe, I can hold this.
There's not on the computer. Right? You got not on the-
This is muted. This is not me.
Did you turn off everything, Judge?
No, I will. I'll come back and do it. I don't want to set these down. I gotta.
Carry from staff.
Thank you.
Yeah.
So it looks like you don't have one in November, but you have the first one in December because of this. Yeah, because we're closed one of the days. So you
I don't
actually
know
have
who's-
2 in December. Just a heads up.
My other one between Christmas and New Year.
Yeah, December 30th. So, I mean, if you maybe ask Al, if they take the day off. So who covered today, Rob?
Dan.
Okay, I have no idea.
idea. So he changed.
Who's? I don't know who's talking.
It's just little people in and out of your pickup.
I don't know. Yeah, I don't know who was talking for the last 3 minutes of that. Okay, so we didn't get a jailed contempt, but we got $300 of contempt. Man, I'm kind of I don't want to say I'm conflicted, but I am kind of conflicted. This guy wasted a lot of time. I mean, accounting, not including whatever OSG cut out from like the dead air. You're looking at, he probably wasted about let's say 2 hours or 1.5 to 2 hours of everybody's time in there with his BS. So I don't like the fact that all he got was a slap on the wrist of $300. That ultimately goes towards paying for the jury. So in other words, he doesn't really get any punishment out of this. At the same time, I do appreciate that. Well, I don't know. I do appreciate the judge remaining professional. I respect the judge's patience in dealing with him. And the only reason why I'm not more upset is because at least it looks on the surface that he got through to him. Given that this guy was, at the end of the day, he was actively listening to defense counsel. It's one of those double-edged sword things. But I would say, like, if this guy comes back at a motions hearing and it reverts back to his Sovcit ways, I feel like he needs to throw the book at him. So, because he was very, like, I mean, at the very beginning, you saw he was very disruptive, very rude, kept on interrupting the judge, kept on talking back to the judge. It was, yeah. But I don't know. We'll see. So I want to go ahead and end it here because this is what the stream is. I do have another, I think it's a Sovcit video. I don't think the other channels have caught up to it yet. I think it's a Sovcit video. There might be, it may or may not be, but I'm like 70% leaning towards these are a bunch of Sovcits. But I'm gonna call it here. I want to thank you guys for watching. I want to thank Biggin for following me for the raid. Everybody, please hit that like button. It really helps the stream. Please check out my merch. www.artysmerch.com. Get yourself a t-shirt. Get yourself a hat. and join my Discord, where you'll find a good community of good people, and you'll be able to find more updates on the stream. Talk with people about sovereign citizens, current events, crazy body cam videos that you see, all that good stuff. Okay. Thank you guys. Take care. Stay safe. And I'll see you next time. All right. Perfect. Adios.